Again, and I didn't, because I was going to submit these, but I had noted this section, and because in the paragraph, the second paragraph mentions the backward flows, and then and actually Hank talked about this too in some of his, we alluded to this paragraph. The third paragraph talks about does more harm than good, and then talks about in general terms, and one of the things I was going to note that part of that, the concern is that you will transfer reverse flows from south to north, and so and that was one of my comments. So I appreciate OSHA putting it on the record this morning, but I would certainly like us to take a look at that before we pass on this executive summary. So,
okay, members, back at the June meeting, communications to Mr. Knopp on ideas, suggestions, comments, observations, reflections. The Natoli Johnston new, clean, brilliantly developed, resolving all questions language would be part of that, and we'll see it in June. Okay. All right, members, let's go now to the third and final package you have before you today, consideration of adoption of the final Delta Plan regulations. Mr. Ray, this is agenda item still 6. It's 6C, I think, isn't it? 6C. Yes, sir. Mr. Ray.
Thank you very much. Yes, this is the third element of the Delta Plan's adoption process, and we're talking about the material that's in the binder here entitled Consideration of Adoption of Final Delta Plan Regulations.
Mr. Chairman, before we get started, could we go over the dates for the next meeting? Is it 13-14 or 27-28 of June?
Mr. Knopp.
That's going to be the end of the month, the 27th, 28th. We had talked a little bit earlier about moving it up to the middle of the month, but at this point, we want to provide enough time to allow adequate review of the science plan, which is going to be the main topic of that meeting.
Well, I'll be in Singapore, unfortunately, at the end of the month. How about the following month, July?
As far as I know, that
25,
one will still be, we'll be moving back to the end of the month schedule.
August, the same.
For July, it'll be the normal fourth Thursday.
25, 26.
And the same in August.
Staff, would do me a favor, when you get back to the office this afternoon, send out as your best estimation of the updated meeting schedules to members so we can all flag our calendars. Very important. I'd rather have it in writing by email than just the memory of a conversation.
Excellent, yeah.
Mr. Chair?
Yes, sir.
If I could, just before you jump into the regulations, this goes back to the Delta Plan. I know we just left that, but Dan, I trust you received an email yesterday. I received it, I think it may have been sent to a member of the council as well, relative to comments on the Delta Plan yesterday as related to the PL 8499 standards and reasons why. And I think Mr. Croce was at the podium at the time, and you were responding to as to why, maybe from a staff perspective, that hadn't been included, that we were taking that approach, and you, because I know I responded to it, specifically referenced that standard would have required the core implementation of removing all the vegetation. Mr. Casio was watching, and so is there anything we could put on the record to clarify? Again, I know that, again, you responded to lots of different questions yesterday, but I just wanted to be clear about that because I know that when I got back to the office last night, there was an email waiting for me.
Yeah, I saw Mr. Casio's email too, and I haven't had a chance to review it with our colleagues at the Department of Water Resources. And, his firm is certainly an expert on the levees of the Delta, so I don't have a reason to expect that he's misinterpreted the Corps' rules. I think what I was trying to convey yesterday was the advice we had received from the Department of Water Resources that attaining the PL 8499 standard across the Delta would be infeasible for a variety of reasons. One is, of course, the availability of existing funds. Another is the difficulty, for many reasons, of complying with the PL 8499 standard, one of which would be the extent of vegetation removal that might be required. And it could be that Mr. Casio's observation is correct, that there would be areas where vegetation could be retained consistent with those standards.
Okay, because I think as we do this levy prioritization, and I guess it kind of going forward as well, that I think we need to be really clear on that because going back to discussion about levy prioritization, risk considerations, costs, and implications of doing certain things or not, I think we need to be really clear with DWR and certainly with our staff about, what those parameters are. So
Yeah, that would be one of the advantages of working with y'all at the DPC as well as with the RDs as we put that together so we can make sure we've got all the details right.
And I'll just put another plug in. That's a good reason why we want to have the RDs on our implementation committee because I think representing, because I think that's the type of information that can help us all. So thanks. No, we'll get a representative, Mr. Eisberg.
Okay, Mr. Ray.
So back in March, we received comments and discussed them with you about each regulatory policy. We reviewed those, and you revised the regulations in response to those comments and voted on each revised policy. Since then, we've posted the revised regulations and the other elements of the rulemaking package for 15 days, and it's required by law in 2 different cycles. The substantive parts of the regulations were posted from April 8th to the 22nd, and the Form 399, which is a summary of the fiscal and economic impact report that we file with the Office of Administrative Law, and the OAL advises us that there's no legal requirement to post that. But we posted it nevertheless from April 24th to May 9th in response to a suggestion we received from the local agencies of the North Delta. Today we're bringing those materials back to you, the regulations back to you for approval. And those are included the regulations are included as attachment 1A in your binder.
Yeah. Mr. Ray, I just want to ask one question, we chatted about this. Right behind the regulations is something called Appendix 1A, but it's really an extract from, I think it's either the Delta Plan or the EIR, I forget which,
It's the Delta
of
Plan.
material that appears in full, and you simply attach this information not because it was new, but because it was easier to refer to than having us flip back and between 2 documents, as I understand it.
Yeah, and I think maybe somebody from our regulatory team could explain its relation to the actual text of the regulations.
Yes, there are a number of appendices and to the regulation, and so you have the option under rulemaking law either to incorporate by reference or to actually attach as appendices.
Here's what I want to clarify.
Right.
I recognize the documents, but I spent time going through them, assuming incorrectly that there were massive changes or significant changes since the last time we saw them, because there was no notation to the contrary in the packet. I found no significant changes. I don't object to them being attachments to the regulatory package, but what I wanted to clarify with you is that these are documents from existing Delta Plan documents, and they reflect those documents, and they're not new. That's
Right.
all I'm trying to
You're right,
establish.
Yes.
Okay.
Yeah.
Yeah.
Got it.
We've also included in the materials before you for your information other elements of the rulemaking package, the statement of reasons, the response to comments, and the cost analysis. And these are staff products. You're not required to approve them, and we'll continue to make sure that they're in the best shape possible before we file them with the Office of Administrative Law. And I want to then turn the discussion over to our Deputy Attorney General, Dan Silver. He developed a memo for us about the Council's regulatory authority in response to many comments that we received in the regulations, and that is also part of the packet before you. And then Steve Hatchins from CH is responsible for the remaining rulemaking package. So, again, our suggestion is that we're here to answer any questions you might have about the materials before you, and then we suggest you open the hearing.
Okay.
And take
Mr.
public
Siegel,
comments.
did you wish to give any introductory comments before we ask any questions about this?
If the council likes, there were many there were many comments on the proposed regulations which question your authority to adopt.
You got to turn. Yeah,
Is this on now? Okay.
Yeah, there you are.
If the council wishes, there were many comments on your regulations which question your authority to adopt the regulations, either to adopt regulations in general or to adopt specific regulations. And if you like, I could go through briefly the responses that we have to that. We believe you very definitely have the authority to adopt these as regulations, and I would outline that if the council wishes.
What's the pleasure of the council? Mr. Natoli says yes. Give us a summary.
Okay.
I know you've given us a copy of in the packet of a generalized summary, but please go ahead.
There basically was a number of commenters said that you have no authority to adopt regulations at all, and then commenters said, other commenters, and the first ones as well, had said you have no authority concerning specific areas of the law, and I'd like to review both the general comment and 4 of those areas of the law. As to the general comment, the comment is inconsistent with your act, the Delta Reform Act. The Delta Reform Act requires that the Delta Plan include an enforceable regulatory component. It leaves you with a lot of discretion as to exactly how to craft that component, but it does require an enforceable regulatory component. And that's repeated in various parts of the Delta Reform Act. For example, it calls for a, quote, legally enforceable Delta Plan. And that's, by the way, if folks have the little handy booklet, that's on page 19 of your booklet. It goes on and it repeats the same concept by saying that the Delta Reform Act is creating a governance structure with the, quote, authority, close quote, to achieve listed objectives, such as restoring the Delta, providing for statewide water conservation and reduced risks in the Delta. That's on page 20 of the booklet. Your act set up an enforcement procedure in which it created this concept of covered actions, and local or state agencies that engage in or proposing an action that might be covered by your plan and that might meet other requirements have to file a certificate of consistency with you that's saying that their proposed action is consistent with these regulations that you're considering today. So that's the enforcement mechanism that the Act created. The legislative history reinforced that the Council's role of, quote, enforcing consistency, close quote, with the Delta Plan is a, quote, critical component, close quote, of the Act. And the legislative history contrasted that with the CalFed program, under which there was no enforcement authority. The Act, therefore, requires that the Delta Plan include an enforceable regulatory component. So that's, answers basically the claim that your role is limited to a coordinating role and you don't have a regulatory or enforcement role. It's just inconsistent with what the Act expressly provides. Another type of, one of the specific comments that you received, and you received a number of these, concerns your appeal provisions. And the assertion was that you don't have the right to have an appellate procedure which can ultimately stop a project. There are 2 problems with those claims. The first is that they're being made, the comments are being made at the wrong time. You already adopted those procedures. You adopted them back in September of 2010. So they're not part of this regulatory package in the first place. So the complaint's being made at the wrong time, in the wrong forum. The second problem is it's just wrong, that your procedures that you adopted back in 2010 track the Act. And we, in the handout that we have, we quote from the Act and explain how the Act works and how your procedures precisely track the Act. Another comment, or a number of commenters said that the provisions that you have concerning land use are improper. That land use is something that has been delegated to local entities, and that this body has no authority to engage in any have any land use regulations. And that once again just ignores what your act expressly provides. The legislative intent says that, quote, state and local land use actions, close quote, that are covered actions are to be consistent with the Delta Plan. So the legislature, very much with its eyes wide open, delegated to you the authority to regulate land use in the Delta. Kind of probably the most comments that you received, and something that you've heard about during many of your meetings, has been regarding WRP1, which is 5003 in the proposed regulations, and that's the policy that you adopted, and what will be a regulation if you adopt it. That certain in-Delta projects that would harm the Delta ecosystem are inconsistent with the Delta Plan if they're needed because beneficiaries are not taking certain steps to reduce their reliance on Delta water. And a fair number of commenters said you have no right to adopt a policy such as that because it looks at out-of-Delta actions, and your authority is limited to actions that take place at least in part in the Delta. The reason why you're authorized to do this is because it is based upon in-Delta actions. It is only triggered where someone proposes a project in the Delta. If there's no project proposed in the Delta, this policy is merely a recommendation. It is not an enforceable policy. And it's only triggered where that proposed project would have a significant harm on the Delta ecosystem. An in-Delta project, your policy essentially provides an in-Delta project to use Delta water is inconsistent with the Delta Plan if it would significantly harm the Delta system, and in addition, it is needed because beneficiaries have failed to take certain steps aimed at reducing reliance on the Delta. So it is authorized by your Act's directive to protect and restore the Delta ecosystem. Mr. Stevens mentioned it yesterday that there are additional pointers or indicia indicating that why this policy is authorized. And besides what I just reviewed, there are express provisions saying that, for example, the Delta Plan shall promote statewide water conservation and efficiency. And some commenters have said, well, the word promote means you don't have the right to regulate. You only have the right to kind of encourage in some non-regulatory way. Well, among other things, the California Supreme Court has held that promote includes the right to adopt a regulation that prohibits a specific activity. So although promote does not mandate that you prohibit anything, promote gives you the discretion to use your regulatory power in a way that could include prohibiting an activity. So basically, all of these provisions authorize WRP1 if it's a policy that you wish to adopt as a regulation. Finally, a number of commenters have questioned your right to regulate areas that are also covered by other regulatory entities, such as by the Delta Protection Commission, State Water Board, or the Central Valley Flood Protection Board. And the commenters are right that the Council has no jurisdiction over, quote, a regulatory action of a state agency, close quote. So, for example, the council lacks the authority to direct the Delta Protection Commission from banning certain development. You cannot tell another regulatory agency how they are to act or whether they can issue a permit. You can, however, exercise your own concurrent authority over areas that other entities may be addressing as well. And again, the California Supreme Court has recognized that projects may be subject to the regulations of multiple agencies. And the reason for this, as a policy point of view, is that agencies can have a different jurisdictional reach or a different focus. And to give you one example, the Delta Protection Commission regulates land use in the Delta, as do some of your proposed policies. The Delta Protection Commission's regulations, even to the extent if you had identical regulations, they would still have a different effect, because the Delta Protection Commission's jurisdiction is limited to something called the primary zone, which is very much a subset of the Delta, while your jurisdiction extends to what's called the secondary zone, another large part of the Delta, as well as the Sassoon Marsh. And potentially, if your regulations are, if your Delta plan is approved under the Coastal CZMA, Coastal Zone Management Act, your plan will be able to control federal actions as well, which the Delta Protection Commission plan can never control. So even though you might have an identical regulation, its reach would be very different. So it's proper for you to adopt regulations even if they overlap regulations of other entities. The draft master response that's in your materials and our basis address some other comments that were made as well regarding authority, but these are the biggest. So these
Master responses are attachment 2B in your packet, and well worth looking at if you haven't done that already.
So we think you're on very solid grounds in terms of authority for the regulations that are before you.
Okay, questions on this, Mr. Siegel's comment? Don.
Yes, thank you, Mr. Chair. Just briefly, the comments we received, a couple areas, again, that you didn't touch upon. We had comments on the regulations as they constitute taking of property without compensation, and also how they affect water rights and area of origin rights. Could you talk about those?
I'd be happy to. Those are we address those in detail in the master responses. Right, yeah, but let me kind of give you an overview. Takings. Basically, takings law provides that if you adopt a regulation whose impact on property is so onerous, this is the U.S. Supreme Court's phrase, so onerous as to amount to the equivalent of eminent domain, of direct condemnation of property, then it's likely to be a taking. The courts also say that a claim that a regulation is a taking is extremely hard to make if the claim is that on its face the mere enactment of a regulation amounts to a taking, as opposed to how it's being applied to a particular piece of property. And the reason for that is that the courts, the U.S. Supreme Court and our state Supreme Court, say that if there's any possible application of an adopted regulation that would avoid a taking, it's not a taking on its face. So the mere adoption of a regulation is not a taking unless, no matter how it's applied, it's going to be so onerous as to amount to the equivalent of eminent domain. Your regulations, among other things, allow for existing uses, so it's unlikely that they would be so onerous as amount to a eminent domain, because they're allowing the continuation of existing uses. Where they are limiting future uses, they allow, there's flexibility, such as allowing the use but requiring mitigation. So it's hard to imagine how even applied any of the regulations could amount to a taking. But if somehow or another we didn't anticipate something, one of the regulations you're adopting, it was 5016, is basically a safety valve. And it provides that if any of the regulations can only be applied in a way that would amount to a taking of property, whoever is applying the regulation is authorized to adjust the regulation to avoid the taking. And this is borrowed from statutes that exist elsewhere. In fact, it's almost identical to the Coastal Act, to a statute in the Coastal Act, which gives the Coastal Act the ability to avoid a taking, and it is exercised to avoid a taking, where a strict application of its regulations would have otherwise amounted to a taking. So it's given this package, it's impossible for your inaction of these regulations to amount to a taking.
Members, on the master answer, it appears that this discussion in part appears on pages 6 and 7. And on the water rights stuff, Dan?
As to water rights, there's no changing of water rights that's occurring through your regulations. What your regulations are doing is they're saying that certain projects are not permitted if they would cause an environmental harm, and that may affect the manner in which someone could exercise their water right, but it would be the same as if a zoning, if say someone wanted to build some plant through a residential neighborhood which is not zoned for a water plant, you might be able to, Sacramento County may say, "Oh, we're sorry, you can't build that plant here because this is contrary to our regulations." That's not a taking of a water right. That's upholding your zoning laws. So I don't see where there's a taking of a water right in your regulations. There was a claim in, I think, one of the comments that, in essence, by requiring conservation, if there's in-delta conservation, that amounts to a transfer of water to Southern California. If I could.
It's under the theory that mandating conservation on some people is somehow illegal?
And that I guess the
Constitution.
it wasn't fleshed out very well. But I think what they're saying is that would free up water, and the water would somehow then be grabbed by others.
It's the right to use water even if you're using it imprudently.
There are a series of problems. I mean, one of them is that your regulation doesn't say that the water has to be used by anyone else. If water is conserved in Delta, it could be used for expanded growth in the Delta. It could be used for other industry. It could be used to address salinity in the Delta. It could be used for the Delta environment, to enhance the Delta environment. There's no transferring of that, taking of that water and transferring it to another party. So that that one just doesn't track. I guess those are the two.
Okay, other questions of Mr. Siegel on these issues? Question? Okay. Dan, I think you want to probably walk us through the errata sheet, which is, I think, next in the agenda.
So
we can at least run it to that. This is item 6C, attachment 1B, staff suggested technical non-substantive changes. These are the only changes, to my knowledge, that the staff is suggesting we consider. It's a one-page document with lineouts. It appears to me, I could be wrong, but it appears to me that there are no substantive changes in that, Mr.
Yes.
That says that, Mr. Siegel, that's your concurrence too. There are no substantive changes in the errata.
There are no substantive changes.
Okay. Take a look at that if you would, members, please. If you're satisfied with that, this would be automatically included in the draft resolution the staff has presented to us, Resolution 2013-3.
And that resolution also authorizes staff to make any further similar non-substantive errata that it may find.
Yep. Questions on the errata stuff? Questions? Okay. All right. Let's see. The next item that I have, let's see, what is it? Attachment 2A is the final statement of reasons. And I assume this is much like the previous stuff we've done. This is a distillation, summary, digest of other material that appears in other.
Correct. This is something that's required to be submitted to the Office of Administrative Law, and this will need to be finalized and then submitted to that office.
Yeah.
And it basically summarizes the changes from a prior document that you filed at the outset of starting to consider this regulatory process.
And this is a staff product.
We call that a preliminary statement of reasons or something like that?
Initial.
Initial. That's right.
And this is a staff product that doesn't require the council's approval.
No, but I want to make sure the council acknowledges it's in the packet. If there are any questions, now would be the time to ask it. Okay. If there are no questions. Any questions on the master responses that have been contained here? These are really very solid and informative discussions, in my view at least, on a range of subjects. It's attachment 2B to this item. Patrick?
Yeah, I have a question for Dan. What weight do they carry in the future?
What weight do these responses carry?
Yeah.
The importance right now is for these are really for the Office of Administrative Law. They will be reviewing these regulations to see whether or not the regulations are authorized, and these responses basically are to show them that these are authorized. In terms of the future, these could be used in this form or in another form to defend any litigation, any lawsuit. But the actual purpose of the master responses is to inform the Office of Administrative Law. So the legal import is
in the future world, possibly of litigation, the responses are akin to sort of legislative hearings and analyses on the meaning of a statute.
That's a good question. If the Office of Administrative Law approves your regulations, that would add weight to the legality of your regulations. Now, I'm not sure whether or not this would be part of what they had considered. So this would support their determination that your regulations are valid. Yeah.
But would it not also add weight to decisions we make pursuant to those regulations once they've been adopted by the Office of Administrative Law? Isn't that the whole idea? So we act pursuant to regulations approved by the Office of Administrative Law. And the court would be obviously influenced by the correctness of our...
It should be, yes. Yeah, yes.
Okay. Any other questions on master answers?
Yes.
Don.
Mr. Chair, just as it relates to the comments received regarding non-native species, and I think the Central Delta Water Agency weighed in, was one of the commenters on that, and they raised, I'm back to the issue of striped bass and black bass, but also I noted that there was concern that somehow there wasn't coverage provided for pheasants.
I'll have to
turn
over to the policy people.
And again, but I mean, when there's just be clear on the regulations, not so much we talk about certain species, although the bass and striped bass obviously has been much discussed, and we've had conversations before this council on that. But when I saw that in there, I'm thinking, so people start carrying the interpretation of non-native introduced species, and they start taking to game birds now, for example.
Do you know who made that comment? I'm trying to remember.
It says, well, on page 4 of the,
This is a staff memo?
yeah, staff memo, yes. It just, if I go down page 4, the last bulleted point there, Mr. Chair, it says the Central Delta Water Agency provided criticism regarding certain definitions, but that last line on the page.
Yep, this was a comment on section 5009, read number 5009 of the regulations. And the Central Delta Water Agency and others have argued that both the regulatory policy and the Delta Plan and then this regulation itself, because the regulation says that the potential for new introductions or improved habitat conditions for non-native invasive species, striped bass or bass, has to be fully considered and avoided or mitigated in a way that appropriately protects the ecosystem. And they've pointed out that the Reform Act requires protection of valuable species and also protection of outdoor and encouragement of recreation in the Delta, and they've emphasized the importance of hunting for upland game, including pheasants, and suggested that somehow this regulation would limit management for pheasants or other upland species, and I don't believe that's true. There are a couple of ways. One is, and we have our friends from the Department of Fish and Game are still here, but I doubt anyone would imagine that people would think of pheasants as being within their definition of non-native invasive species. I mean, we had this question about were bass and striped bass within that definition, and so you specifically added them to make it clear that we were trying to cover those species. In addition, those species are already introduced. I think new introductions, I don't know the rule, but I would not be surprised if someone was wanted to introduce a new species of upland game animal for hunting purposes, if the Department of Fish and Game wouldn't have a regulatory program to oversee that and ensure that there weren't invasive qualities to those animals. And then finally, of course, through the Delta protection, through our regulations protection of agricultural lands, which is where the vast majority of pheasant hunting occurs and where the upland game habitat is most often found, we're actually protecting habitat for pheasants and making that recreation opportunity possible. So I think we're really not in any way impairing the opportunities to protect upland game and for those species to thrive within the Delta as they do today.
Well, I appreciate the response. Again, I was concerned that the regulations, the unintended consequences, and so you're saying that, to the contrary, outside of calling out for the striped bass and the bass, that it does not impact. In fact, there are things that actually encourage.
Yeah, I would find it inconceivable that anyone would use this regulation to prohibit the management of lands, the private lands for pheasant hunting or whatever, or wildlife refuges either, for that matter.
Okay, I don't have any more questions. Like I said, and I appreciate the answer. We have Mr. Zajalek, Davis here. Maybe could you weigh in on this, Fish and Game?